Good afternoon, everyone. Welcome to our webinar on monetizing your patent portfolio, brought to you by the Lathrop GPM IP Litigation Group. Before we start, I would just like to take a couple of minutes to introduce all of our panelists for today. So my name is Angela Grant. I'm of counsel in our Boston office. I actually started my career as a research scientist and received my PhD in immunology and microbiology. So my current IP practice focuses mainly in the areas of biotechnology and pharmaceuticals. I've also asked each of our panelists today to give one example of how they're continuing to entertain themselves and their families during the pandemic. So for me personally, I love to travel, so I've been using the extra free time at home to plan my next trip. And our next panelist today is Tucker Griffith. Tucker is also a partner also in our Boston office. He has over 20 years experience prosecuting and enforcing IP rights. His prosecution practice focuses largely in the mechanical and electromechanical space, including medical devices and consumer products. Tucker's litigation practice includes representing clients in federal court and also before the International Trade Commission, the Patent Trial and Appeal Board, and as well as the Trademark Trial and Appeal Board. Tucker has found that his trivia knowledge has been helpful to entertain his children throughout the pandemic. Thank you and welcome, Tucker. Our next panelist is Lauren Hansen. Lauren is a trial partner in our Minneapolis office. He has handled a number of high-stakes litigations, including recently handled an appellate argument before the North Dakota Supreme Court. Lauren has found the silver lining of the pandemic that he doesn't have to commute to the office every day, and that gives him some extra time to do things with his two kids, such as hiking. Thank you and welcome, Lauren. And our last panelist today is Tim Hadachek. Tim is an associate in our Kansas City office, and Tim has experience litigating all types of IP disputes, including patent, trademark, copyright, trade secret, and false advertising claims. Tim has represented a number of clients in different industries, including consumer products, oil and gas, and transportation. During the pandemic, Tim has assisted his wife in completing 5 jigsaw puzzles, and they are currently working on a 6th. Thank you and welcome, Tim. Before we get started, just a couple of quick housekeeping remarks. So you're welcome to ask questions throughout the presentation. If you have a question, please use the chat feature and we'll get to as many of those as we can either during the presentation or at the very end. And we'd also be happy to follow up with you if we don't get a chance to address your question today. This webinar will also be recorded and will be available on the Lathrop website within 24 to 48 hours. We'll also send you a follow-up email directing you to that webpage. A CLE credit has been approved for California, Missouri, and Minnesota, and follow-up information will be sent to those of you who logged in today regarding CLE. And lastly, we have also included a couple of poll questions throughout the presentation, so we will pause for a couple of seconds at each one to give everyone a chance to participate today. So with that, we come to our first poll question. We thought it would be nice to start out to give us an idea of where everyone is joining us from today. And so what's the weather doing in your area? It's beautiful, can't wait to get outside. Cloudy or rainy, but there's nowhere to go anyways. Hot, bring on the fall weather. Or I haven't been outside all day, so I don't know. And well, that's great. It looks like some people, most of us are enjoying beautiful weather today. So thank you again for joining us despite it being so nice outside. With that introduction, let's dive in with our first panelist, Tucker Griffith, who will walk us through an overview of how to evaluate, expand, and enforce your IP portfolio. Tucker?
Thank you, Angela. So patent portfolio can be one of the greatest assets that any company owns. Patents can convey great value and provide many avenues for sustaining and growing business operations, including taking advantage of the exclusionary power of the patent to create a foothold for your technology and to stake out territory that forces competitors to design around your patents or risk suit as infringers. So today we'll discuss crucial steps for conducting an accurate portfolio assessment, identifying strengths and weaknesses in the patent rights that could foster further innovation, informing a licensing strategy, or encouraging third-party litigation funding. We'll also review development in design patents as design patent enforcements as another means for expanding and enforcing your portfolio. And then lastly, we'll consider additional enforcement strategies, including guidance for proactively pursuing infringement while preparing for invalidity challenges. Next slide. So a patent confers to the owner the right to exclude others from infringing activities, such as use, manufacture, sale, or importation of infringing products. And the owner of a patent portfolio has options. They can enforce their rights against trespassers, such as through legal action, or they can leverage those rights for revenue through licensing. As we will discuss today, these monetization decisions are influenced by many factors, including how strong the portfolio is, how the portfolio can be strengthened further, and what the economic impact of the portfolio is. Just briefly, there are other advantages provided by the patent asset beyond enforcement and licensing. For example, patent portfolio can provide value to the company for which can lead to investment or sale. I have a client that I began working with when they were a startup, and together we developed a very aggressive patent prosecution strategy. And for their consumer products, we were able to file utility patents and design patents and be very successful, getting almost 100 issued patents within 10 years. They were able to enforce these patents against copycats, but very recently they sold their business for an 8-figure payment, and the focus of that sale was largely on the strength of their IP portfolio. An additional benefit is provided by an added cachet in the marketplace. There's a PR benefit to being able to advertise your patented technology. Next slide, please. So given the value of patents to a company, it's important to continually evaluate how the patent asset can be monetized for the best benefit of the company. As already noted, the key aspects are enforcement and licensing, which often can go hand in hand, but other areas where monetization is available is through production of products in the marketplace, continued innovation and expansion, or a continued patent prosecution strategy. Regarding enforcement, a patent can be enforced by filing an infringement lawsuit. There are also advantages and benefits to simply sending warning letters or cease and desist letters to see how competitors and infringers will react. Alternative approaches are also available, especially if injunctive relief is more important. So for example, you can seek an exclusion order from the ITC to prevent importation of infringing goods, or you can seek confiscation of counterfeit goods by the Customs and Border Protection Agency. Regarding licensing, licenses are a valuable resource for a valuable revenue source, but even beyond licensing, if there's technology that you have patented that's no longer important to your company, you can sell those patents to other companies that might be interested in that technology. There are many factors to consider when structuring such licensing or transfer of assets agreements, often influenced by the strength of the patent, but also by prevailing market conditions and the competitive landscape. License agreements can be exclusive or non-exclusive. They can be multinational or geographically limited. You can have an arrangement based upon a flat fee or a royalty fee arrangement. Filing lawsuits to protect your patents can be extremely expensive. And while there are avenues available to fund such enforcement actions, there are also other ways to monetize the portfolio that can place your company in a better position for when the time is right to file lawsuits. So some of these other areas are that patents can be monetized simply by the company being able to produce and sell its own products as protected by and marketed under the exclusive patent right. Such sales drive the bottom line. Plus, the mere existence of patents can offer a deterrence to direct knockoffs. Similarly, a company can increase its own market share by being better than weaker alternatives. So if a competitor is able to design around their patent, your patent, it may not be as good as the patented invention, so you can get a benefit from that. Patents also provide a basis for continued innovation and expansion of your technology through investment into R&D, covering improvements in the technology, increasing your zone of exclusivity, considering prevailing state of the art, and tapping into new areas. And in the same vein, companies can also consider expanding the patent portfolio itself through continued patent prosecution, balancing the value that you gain by the exclusive right with the expense for filing applications, considering protecting your products through both utility patents and design patents, targeting your patent prosecution strategy to improve your enforcement opportunities. For example, targeting claims to directly read on competitors' products to strengthen those infringement claims. So as you can see, there are many ways to monetize the patent portfolio. I believe we have our second poll question.
Great, thanks, Tucker. So our second poll question, in 2019, the USPTO granted an all-time record of 333,530 patents, which represented a 15% increase from 2018. Which of the following companies received the most patents in 2019? IBM, Apple, Amazon, or Samsung? Great, and the correct answer, 53% got it right, IBM, who actually received 9,262 patents in 2019. So keeping that in mind, Tucker is going to pick up with an overview of how to think about assessing and strengthening a patent portfolio.
Thank you, Angela. And also an interesting note regarding that last poll question is that IBM has led in patents issued for the last 27 straight years. So while a lot of people might think of the new up-and-coming technology, sometimes it's the old guard of the technology companies that still hold strong in terms of patent filing and getting patents. But all of those companies, IBM, Apple, Amazon, Samsung, and many, many more, are obviously the big players internationally with massive portfolios covering varied and numerous technologies. But even for a small startup company or an inventor with just a single patent, proper steps to monetize that single patent can improve your bottom line. Understandably, the true value of a patent is difficult to ascertain, and growing a portfolio can be expensive to both procure and protect. So there are many steps that can be taken to appreciate and realize the full value of the patent portfolio and in turn inform a monetization strategy. First and foremost, a full portfolio assessment is advisable. This is the best way to identify both the strengths and the weaknesses of your patents, which will ultimately influence and dictate how the portfolio can be monetized. But more than just determining how strong the patent portfolio is, a full assessment can identify areas for making that portfolio even stronger, especially once you identify areas of weakness. Hopefully you can look into areas where you can improve upon them. This initial assessment can help determine what's the next steps should be, and more importantly, whether additional steps such as enforcement are even advisable. For example, if you determine that a patent is weak and is easy to design around or is not likely to survive an IPR challenge, then it may not make sense to file a lawsuit yet. So hopefully in this scenario, there's a pending continuation application where valid claims can be secured in view of newly discovered prior art, or which can be used to limit design around opportunities. And then the enforcement decision can be reevaluated. And also this step can greatly reduce the risk of an IPR challenge by eliminating a competitor's best potential prior art from consideration altogether. The lesson, however, is that taking these steps early is important. Benjamin Franklin said that an ounce of prevention is worth a pound of cure. And spotting potential issues when corrective actions can be taken can mitigate the lost investment of resources. So what should this initial portfolio assessment be covering? Well, first starting point is looking at the scope of the patent claims, because the claims are going to be what's going to be enforced against infringers. And so it's important to look at how strong those claims are, how broad they can be interpreted. But things to look at in that regard are, is your own product adequately covered? This can help strengthen the value of the patent for negotiations or damages purposes. But also you have to figure out, have you adequately covered your invention through both utility patents and design patents, which are available? Another area of inquiry would be, how would these claims, once you determine the scope, be infringed? Is it easy to reverse engineer a competitor's product to figure out an infringement one-to-one matchup? Or would it require multiple infringers, which would make the infringement argument much different based upon recent court case law? You also want to look at how easy it is to determine infringement. I mentioned about reverse engineering a product, but in some situations, in order to determine infringement, you would need access to a competitor's confidential information, which understandably you're not going to have access to unless and until you file a lawsuit against them. In this analysis, you also look at how easy the patent might be to design around. So if you enforce your patent against a competitor through a litigation or even sending a cease and desist letter, what steps can they take that are going to be easy for them to get around it? If it's easy to design around, then enforcing your patent might not be the best opportunity, best option. So you look at the opportunity of expanding that right. So when you're evaluating the patent, it also reaches into areas where you can assess it for strengthening that portfolio. Also, at the same time, you want to review the patent landscape, not only the scope of your patent claims, but also what is the prior art covered? Where are technology gaps in the patent landscape? So you can ask yourself these questions of, can my coverage be expanded using continuation applications? Can I expand my coverage by filing both utility and design patents? Can I expand my coverage to get patent coverage that directly reads upon a competitor's product to improve your case for infringement? And then lastly, where I talked about technology gaps, are there any gaps in the technology for new R&D or where patent applications can be proactively filed? Next slide, please. So an assessment of the patent portfolio should also consider how strong the patent is in view of potential invalidity challenges. So later, my colleague will discuss challenges of the patent before the PTAB in more depth. But as part of your initial portfolio assessment, when considering the value of the portfolio, it's advisable to prepare yourself to stave off any challenges from competitors and infringers. So the most common challenges before the patent office are inter partes review, post-grant review, and to a lesser extent, but equally problematic, an ex parte reexamination. And any of these challenges to your patent can slow up your enforcement strategy, especially if you file a lawsuit and an inter partes review is filed against your patent, and it could really slow things up. So looking at it early and assessing it early and being predictive can help you prepare for any type of challenges down the road. Now, assessments must also be mindful of whether patent claims can survive Section 101 patent eligibility challenges, especially for computer-based inventions, as the law in this area is constantly and continually developing. Reviewing your potential weaknesses in your portfolio in view of the prior art landscape and considering how a patent is likely to be challenged can ultimately inform your enforcement strategy. You can balance whether to send a cease and desist letter as opposed to filing a case. You can figure out what the best timing of either providing notice or filing is. You can determine what your initial and long-term investment can be. And you can consider a number of questions, such as whether you should enforce the patent at all, and if so, how aggressive should your allegations be, whether it's worth the investment to go after infringers and when, whether you want to steer a discussion towards negotiating a settlement or a license, or instead stand firmly in going for injunctive relief. Next slide.
Thanks, Tucker. And just one additional point to make here, there is an additional benefit of knowing the prior art landscape in that it can really help you craft your forward-looking IP strategy and improve the value of your patent portfolio that way as well. in that if you know what the prior art is, you can really draft your patent claims for new filings with that prior art in mind.
That's an excellent point, Angela. And plus the strengthening and broadening the patent coverage always increases the value of the portfolio, as the economic impact of the patent portfolio is generally interrelated with factors such as how strong the patent portfolio is, the scope of the patents, and whether the patents cover commercial products to the extent you can attribute value to your invention. So, looking at the patent quality, in connection with such of a prior art landscape review, an assessment of your patent scope, really gives you an understanding of the quality of the patent and the strength when you ultimately go to enforce it against infringers. The provable use of your patented technology in the market through your own products can also increase the value of the patent. That especially comes into play when you're trying to get damages and determining what a reasonable royalty is, especially if you attribute value to the invention itself. Other considerations include the remaining lifespan of the patents, other existing licenses that are out there, how much competition is in the market, both infringing and permissible non-infringing uses. What other types of successes have you had in terms of enforcing against infringers? Optimally, the value of the portfolio is used to determine a reasonable royalty for licensing negotiations, as well as to set a standard for settlement negotiations for any existing or potential litigation. The evaluation of the portfolio can also assist in a predictive damages analysis for infringement matters, which again can be used to determine your enforcement strategy. So for example, if your assessment of damages are that they are low or even unlikely, then an investment in a lawsuit may not be merited unless the injunction is what you're looking for. On the other hand, if damages are high and easy to prove, then that can inform an enforcement strategy that's very aggressive and pushing the case towards resolution or settlement. Next slide, please. So once you've evaluated the strengths and weaknesses of your patent portfolio, considered the value of the portfolio, predicted possible challenges to your patents, an important step in maintaining that portfolio is enforcing the patent against infringers and copycats. Patent litigation, I'm not going to deny, can be very expensive. Estimates put the cost of between $3 to $5 million per case, especially for complex technology. So as a result, companies must often balance these projected enforcement costs with day-to-day operating expenses, or consider alternative or creative, less ideal approaches to patent enforcement, including a complex contingency fee arrangement, considering an ITC action as a less expensive alternative, or by staggering your enforcement or filing of cases. But another option is to consider third-party funding. Litigation funding involves a third party funding a portion of the fees and costs of a patent litigation in return for a share of any award or licensing revenue. As a result, the patent owner doesn't need to pay all the costs and fees of the litigation, which can be very helpful when resources are needed for company operations or to support continued R&D. And additionally, such litigation funding is generally non-recourse funding, which means that if the claim is lost, the patent owner is not responsible for paying back the funders in full investments. Next slide, please. So the use of litigation funding is becoming more and more common because of the advantages afforded to patent owners, as well as the attractiveness of potential high damages awards. Funding can place smaller patent owners on equal footing with larger infringers with deeper pockets. It's optimal for the one-off case, a single matter where you can keep the funding relationship and the return discrete. But it's especially true if there are multiple infringers, both multiple patents that are being infringed or a strong patent that's being infringed by multiple competitors. And this way, funding can be spread across multiple cases, and the return can be collateralized across the portfolio. This portfolio approach also broadens the range of cases that are viable for funding, avoiding both the heavy reliance on either the nuisance model of low risk but low return cases, or the Hail Mary model of high risk, high return cases. Next slide, please. There are other advantages to litigation funding. For example, the client can avoid onerous contingency fee arrangements, also generally maintain control over the selection of counsel. As noted, litigation funding is commonly non-recourse, which allows a patent owner to hedge some of the risks of litigation, even if they can pay for it. This allows them to gain the benefit of a victory without bearing the entire weight of the loss, and spreads out the risk. Perhaps most importantly, a litigation funding review provides a second opinion. It's an opportunity for you to determine if your enforcement decisions are worth it. Because clearly third-party litigation funders are mostly interested in funding meritorious claims. So they will often undertake their own separate analysis, usually enlisting the help of a different law firm to kick the tires of potential cases. And this second opinion generally requires pre-action due diligence review that aligns with the portfolio assessment that we discussed before. So to look at the same type of things, conducting an infringement analysis and an invalidity analysis, doing a claim scope review. But it's also an opportunity where the litigation funder will do their own independent damages analysis to determine, again, the merit of the claims. The results of the second opinion can be useful in setting settlement guidelines, identifying what a realistic budget would be, and contribute to the development of a total filing strategy. Once an arrangement is set, the funding will typically cover at least all of the hard costs and generally a percentage of the attorney's fees. And commonly those fees will be discounted, fixed, or capped. But in general, the arrangement is designed to allocate the risk between the client and the funder while aligning their interests. One issue, however, is that such arrangements often make settlement more difficult because now there are more parties that must be satisfied with the terms of the settlement. Next slide, please. And one last point regarding the initial portfolio assessment. In connection with that assessment, it's also advisable to evaluate whether there is any insurance coverage available. As your company is looking to monetize its patent portfolio, it's safe to assume that competitors are doing the same thing. So your own marketplace activities or enforcement actions against competitors could trigger that competitor's assertions against you. So depending on the allegations, defense of the litigation may be covered by insurance. But availability of insurance coverage for IP assets and allegations of infringement depends on the language of your insurance policy itself. Many policies have very broad exclusionary language for IP-related claims. For example, injuries arising out of infringement of IP rights, and thus coverage may not be an option. However, you shouldn't automatically assume that no coverage is available. The specific language of the policy and the specific nature of the allegations and claims that have been asserted against you, as well as all the underlying facts, must be examined closely. For example, coverage may be available where theories of liability extend beyond cookie-cutter claims of IP infringement, perhaps touching upon issues of breach of contract, violations of confidential information, allegations of disparagement, false designations of origin, or other types of advertising injury under the Lanham Act. In any event, in any situation where a claim is made against your company, including a counterclaim to your own assertion of your patents, it's advisable to provide timely notice to your insurance carrier just to see what options are available to you. Slide. So what are some of the key takeaways of looking at how to monetize your portfolio? Well, first and foremost, a full portfolio assessment, identifying both the strengths and the weaknesses of your patents. It can be very helpful in informing your monetization strategy, not only what you can do, but when you should do it. Additionally, steps are always available to be taken to strengthen, increase the value of your portfolio. Look at what the prior landscape is. Look at what your own patent coverage is. Look at what options are available to you. And always work to strengthen that portfolio, which can ultimately improve the economic value of your portfolio. And then lastly, consider litigation funding for enforcing patent rights, without compromising the resources needed for operating your business or investing in R&D. A lot of expense has been put into getting your patent portfolio, and so if you have people who are infringing upon it, you want to look into the best approach for enforcing and monetizing those patents. Thank you.
Thank you very much, Tucker. And I think we got 2 questions in the chat that we can probably go ahead and address now before we move on to the next section. So one, in the context of whether the product is adequately covered by your patents in your portfolio, would you consider both composition of matter patents and things like methods of making, methods of treatment, or are you really focused on one type of claim versus another?
That's a good question. Me personally, with my clients, I'm always looking at identifying the best way you can fully protect your product. So if you're looking at the methods of manufacture, methods of use, those always improve the scope of that portfolio. It gives you multiple options. And especially if in situations where before I mentioned a situation where how easy is it to determine infringement? Well, sometimes the method of use is hard to figure out, or the method of manufacture. But if you have multiple patents, there might be a patent that's easier to determine. That justifies filing the suit. Once you have the suit filed and you have access to your competitor's information, then you can determine that those other patent claims could be infringed as well, which will either strengthen the case for damages or will set it up for an early settlement.
Thank you. And the second question regarding financing for litigation. How do we find third-party financiers, and is there a typical percentage amount that they get, or is it pretty varied?
There are more and more funders out there, and a lot of law firms have worked hand in hand with them. And so I think it's generally pretty easy to find them, but it's like anything else that you want to kind of approach a couple of different places, see what the best situation is. And the arrangements can be pretty varied. And a lot of time it's going to depend upon, that second opinion that they do. How strong is the claim? What are the damages likely to be? It's like any type of trade-off. What is their responsibility going to be, and what are the chances of them getting a return on their investment? But it's not the arrangement's never overly onerous that it's not worth it to you as the patent owner. It's going to be somewhere in line with contingency fee arrangements, so that by aligning those interests, everybody's on the same page, and it's not going to be benefiting the funder more than it's going to be benefiting the patent owner.
Great, thank you so much, Tucker. So next, Tim Hadachek will walk us through the basics of IP litigation options with an emphasis on inter partes review. Tim?
Yeah, thanks, Angela. Hello again, everyone. My name, as Angela mentioned at the beginning, is Tim Hadachek, and I'm an IP litigation associate based out of Lathrop's Kansas City office. And as Tucker mentioned, an important part of monetizing your patent rights is being prepared to actually assert those rights against infringers. Modern patent litigation often involves several different types of proceedings. Some of these can happen in quick succession or even concurrently. And it's in addition to district court litigation, patent owners might also choose or need to pursue or defend against administrative matters before the International Trade Commission or the U.S. Patent Office. And while there are several types of proceedings, especially before the Patent Office, today we'll discuss one of the most common types of administrative actions that a patent holder might face, known as inter partes review, or IPR. And before we dive in, I believe we have a polling question related to this. So the question, as you can see on your screen, is what percentage of patent infringement lawsuits see an associated IPR filed while the district court case is pending? And you have several percentages there on your screen. As you can see, a lot of you thought that the correct answer was 60%, not far off. The recent data that I found, if you move to the next slide, please, shows that there is an IPR filed defensively in about 50% of patent lawsuits as a strategy that a infringement defendant might use to challenge the validity of a patent as part of their overall strategy in a lawsuit. As you may know, an IPR allows for a challenge of the validity of the patent by any person who's not the owner of the patent. IPR validity challenges must be based on anticipation or obviousness and must be based on prior art consisting of patents or printed publications. So an IPR doesn't have to be conjoined with the district court litigation, but it is often used as a tactic by the defendant in a patent infringement lawsuit. If the defendant does choose to pursue an IPR, the accused infringer must file the petition within 1 year of being sued for infringement. The IPR procedure is intended to streamline the process of validity challenges, but unfortunately, one side effect of that efficiency is generally a greater burden for patent owners due to the possibility of duplicative litigation. You can also see that the IPRs generally don't have there's not much upside for a patent owner if an IPR is filed. The patent office has a lower burden of proof, there's no presumption of validity, you have the extra cost of duplicative litigation, and the problems, if you eventually lose the IPR, it could potentially extend the district court case if the stay is granted. I guess one benefit, one silver lining is that surviving an IPR challenge does head off identical invalidity challenges in the district court. If an IPR trial is instituted, the district court defendant will likely seek a stay of the court case in favor of the IPR. Slide, please. As a result of that, the one big picture strategy that I would hope that you take away from today is that the patent owner should drive the case forward to the extent possible. This means avoiding unnecessary delays in the district court case schedule within your control. Obviously, there are times when things are out of the patent owner's control. Delays in the district court case could be disadvantageous in both the district court and in front of the Patent Trial and Appeal Board. Considering why that's important in front of the PTAB, institution of an IPR trial is not mandatory. The board, of course, has discretion to deny a petition for IPR. The board considers a number of factors in reaching the decision about whether to institute. The most important of these probably relates to how likely the petitioner is to prove its invalidity claims. But another important factor on whether the board will institute an IPR is the state of the district court litigation. The recent Apple v. FinTIB decision is a good demonstration of this principle. In that decision, the board denied institution of an IPR based in part on the fact that a district court trial was set for only 2 months, set 2 months before the board's deadline for a final written decision. Additionally, the district court had issued a detailed 34-page claim construction order addressing the same claims that were at issue in the IPR. Based on those facts, the board determined that it would be not an efficient use of its resources to reevaluate the validity issues in an IPR. Again, obviously, much of this is out of the patent owner's hands. Much depends on where the petitioner actually, when the petitioner actually files the IPR. We are even aware of some recent decisions to institute IPRs based on delays in the district court action due to case extensions due to the pandemic. So again, completely out of the patent owner's hands in that case. But all other things being equal, an advanced stage in the district court litigation can only help the patent owner avoid an IPR challenge. Next slide, please. Now, the same principle applies in the district court action, and if anything, it's more important in determining whether or not the district court will stay the litigation in favor of an instituted IPR. If the board does institute an IPR, the defendant district court action will almost certainly move to stay proceedings in the district court pending the outcome of the IPR. In deciding this, whether to stay, courts have a set of traditional factors, but unlike the PTAB's factors on instituting an IPR, these are all somewhat related to the state of the case before the district court. Most often, courts will grant the stay in favor of the IPR because of that first factor. It will resolve validity issues and thus simplify the case. However, the court does generally have discretion to deny the stay, and denials of a stay are not unheard of. So again, a patent owner can maximize chances of a stay by pushing the case forward to an advanced stage. The patent owner should also consider the trends in possible forums for bringing the initial lawsuit, to the extent that you have a choice. Obviously, this, if you're familiar with the recent case law in this area, this is much more difficult since the Supreme Court tightened the venue rules in a case called TC Heartland. But to the extent possible, consider the trends in granting stays when you are considering where to bring the patent lawsuit. Next slide, please. So let's imagine that in a hypothetical patent infringement litigation, an IPR has been instituted and the district court denied the motion for a stay. The parties are now in a situation of parallel district court and IPR cases moving forward at the same time. This could also arise if a third party challenges a patent in an IPR while the district court case is pending, because as I mentioned earlier, an IPR can be brought by any person that's not the patent owner. Assuming both the district court and IPR eventually reach a final judgment, the question becomes which one controls. In most cases, the controlling decision will be the one that reaches a final decision first. In an IPR, if the board reaches a final written decision and cancels all claims before the district court reaches the merits of its case, then district court action might be entirely terminated if there is no longer a valid patent to infringe. On the other hand, a final, and that word final is important, adjudication in the district court action will control if it is reached first. But Federal Circuit precedent known as the Fresenius-Simmons preclusion principle, that's a tongue twister, effectively extends the time before a district court adjudication is quote unquote final. If any direct appeal issue is still alive, even if it's unrelated to the merits of the patent infringement claims, an intervening inconsistent ruling from the PTAB in an IPR could vacate or moot the proceedings in the district court. This is similar to the situation in the recent Crimar Systems case, and understanding the facts there is instructive. In that case, the patent owner won in the district court with an infringement verdict on 4 patents. The defendant appealed on claim construction issues and some evidentiary rulings to the Federal Circuit. The Federal Circuit reversed and remanded one of those 4 claim constructions, but left the other 3 to stand. Meanwhile, third parties challenged all 4 patents in an IPR, and the PTAB found them unpatentable. Patent owner appealed that determination to the Federal Circuit as well. In the district court action, the defendant sought a stay during the remand proceedings from the initial direct appeal. The patent owner, fearing the estoppel effect from an IPR, sought to insulate the 3 patents that were not reversed on appeal by stipulating to a dismissal and a covenant not to sue on the non-resolved patent. The district court granted that dismissal, and the defendant appealed that dismissal once again to the Federal Circuit. The Federal Circuit decided both that appeal and the appeal of the PTAB decision on the same day. It found that the district court decision was not final while the unresolved patent issue was still live, and therefore the Patent Trial and Appeal Board decision in the IPR, which came nearly 2 years after the district court found infringement, controlled, and therefore the district court adjudication was mooted because of that. The patent owner in that case sought an appeal all the way to the Supreme Court, but the Supreme Court denied cert in June of 2020 of this year. So you can see the risks that might arise from having a later administrative action completely reverse the decision that happened in the district court. Next slide, please. So what kind of estoppel arises from an adverse IPR decision? We've already seen from the last example what happens if the petitioner wins, but if they lose, the petitioner is stopped from raising any ground that was raised or reasonably could have been raised in the IPR. This also relates back to the district court's decision on a motion to stay. We have seen in our practice examples of petitioners stipulating that they will not raise any other validity challenges in the district court as a way to guarantee that the stay in the district court will simplify the issues. The estoppel effect from an IPR attaches even before an appeal of the IPR's final decision. That's one of the ways in which Congress created a more efficient method for adjudicating patents, adjudicating validity challenges, excuse me. On the other side, the patent owner might also face estoppel in addition to consequences directly from the lawsuit. If they lose an IPR and lose the ability to seek another patent with an effectively identical claim from one that was canceled in the IPR. This could have impacts on any continuation or reissue applications, So similar to Tucker's discussion, a savvy patent owner will want to structure their patent portfolio to avoid exposing an entire family of patents to invalidity based on a single IPR. And these are considerations that you should probably take before even bringing any kind of district court action. Next slide, please.
Thanks, Tim. I think quickly before we move on, we have one question that came into the chat related to estoppel. So if institution of an IPR was denied by the PTAB, can the challenger have a second chance by submitting a subsequent petition challenging the validity of the same claim or claims using different prior art?
Yeah, that's an interesting question, and the answer is probably not. As mentioned, the petitioners are stopped from asserting any ground that was raised or reasonably could have been raised in an IPR. So the petitioner would have to have a fairly good reason why that initial prior art was not asserted in the first IPR. And also the guidance from the board generally disfavors successive IPR petitions just because of the potential for abuse of getting multiple bites at the apple in terms of validity challenges on a single patent. So probably not, but there is maybe some room for specific carve-outs in that case. So discussing a little bit about how all of this timing could happen, let's zoom out a little bit and think about exactly what the timing means, both in terms of the IPR and the district court action. Consistent with the goals of creating IPRs to facilitate the efficient adjudication of validity, the board follows fairly rigid rules for the timing of IPRs. First, an accused infringer must petition for an IPR within 1 year, within 1 year of being served with a district court complaint. Some courts have even criticized defendants who waited for the full year before filing the IPR as a way to kind of game the system or prejudice the patent owner. So often the IPR will come even sooner. If the defendant does wait the full year, a practice tip for anyone in a motion to stay would be to be sure to point that out, that the petitioner waited the maximum amount of time before bringing the IPR and opposing that motion to stay. But note that the 1 year does not apply to third parties. So that's similar to the situation in the Crymar case. So that could come anytime before or after filing. So from the time that the actual petition is filed, a decision on whether to institute the IPR will usually come within 6 months. After institution, by statute, the IPR trial, and that's the green phase on your screen there, cannot last longer than 12 months, except in some rare circumstances. Slide, please. So you can compare that timeline with what is usually going to be a much longer timeline in the district court. If the IPR challenge comes early, then it's possible that final written decision could come down well before the district court trial. Often the timeline in the district court the state of the district court litigation will matter a great deal, both as we've seen in instituting an IPR or determining whether to stay the district court litigation in favor of it. Slide, please. And so ideally what you're looking for, as I mentioned, as a patent owner wanting to drive the case forward, ideally the strategy that you want to pursue is to make sure that that district court trial is as far along as possible before the IPR is filed or actually instituted. And that's going to increase your chances of, first of all, of the board denying institution, or even if it does deny, that the district court action could become final before the IPR is resolved. Slide, please. So in summary, 3 big points to take away as a strategy for a patent owner. Don't be surprised if the defendant files an IPR in the middle of your district court case. You should probably assume that they're going to, and factor that potential cost into the budgeting for the case if you would potentially have to litigate both the IPR and the district court case concurrently. Second, as I mentioned several times, avoid unnecessary delays in the district court to head off any arguments the litigation should be stayed pending the IPR, or to rebut arguments in the PTAB against institution of the IPR in the first place. And finally, if you have a choice of forum, consider the practices of the districts in which you have the option to bring the suit. Consider the trends for granting a stay pending institution of the IPR. And with those steps, you can mute some of the disadvantages that a patent owner faces against an IPR. With that, I'll turn it back to Angela.
Thank you so much, Tim. And our final speaker today is Lauren Hansen, who's going to walk us through the value of design patents to an IP portfolio. Lauren?
Well, good afternoon or good morning, depending on where you're at. As Angela said, I'm Lauren Hansen. I'm a partner in our Minneapolis office. And I want to touch on design patents. Usually when we see presentations about monetizing your IP or your intellectual property, the presentation is almost exclusively about utility patents. Design patents are often ignored, as are other intellectual property devices like copyright or trade dress or trade secret. So here I wanted to just touch on design patents for our last 9 minutes of the webinar. Because as I mentioned, they are often overlooked, but they are very powerful, as was confirmed, and I'll talk about in just a little bit. So first, let's take a step back. What is a design patent? Well, it covers the ornamental design for an article of manufacture. And the reason that I have highlighted those is ornamental design is an interesting concept, and then also article of manufacture is an interesting concept, and I'll try to discuss those two with a little bit more precision today. So one of the first things that jumps out, though, when you are thinking about design patents are what are the prosecution considerations here? Oftentimes, design patents are much more efficient to prepare. Instead of a lengthy specification with a number of carefully tailored claims and a mountain of prior art to consider, really what you're looking at are pictures and drawings. And the claims are often tailored as what is shown in this picture. And so they're efficient to prepare, and they're generally faster to issue. Instead of a 2-3 year, prosecution window, sometimes longer for really technical inventions, maybe shorter if you're lucky. But in the design patent context, it's not unusual to see patents issue within a year or less. So then let's talk about what is a design, right? What is worthy or what is covered by an ornamental design. And I think that a lot of people, have overlooked design patents because they think, well, I've got this functional product. I'm going to get a utility patent on it. And functionality is, at least in theory, a defense to a design patent infringement case or to a design patent validity. But really, the case law has evolved in such a way that a lot of useful products can still have ornamental designs covered. And so one of the cases I'd point you to is this Ethicon endosurgery case, where there a medical device had a number of design patent options on it. The one I pulled up here shows that this handle, this trigger for this medical device was covered by a design patent. So that sort of shepherd's staff shape of that trigger was covered by the design. And the Federal Circuit in that case said, well, that's not a useful design necessarily, because there are many ways in which you can design a trigger, is essentially the ruling. So there, the design patent wasn't invalid because it was useful, and they were allowed to continue, at least with respect to the infringement on the design patent there. So next slide, please. And here we have a poll question. Angela, please.
So what is the primary consideration when buying a smartphone? The operating system, another functionality, or the ornamental design? I think unsurprisingly, 56% voted for the operating system. Interesting. So Lauren?
Yeah, and so the reason I put this question in here is I feel like when people are choosing their phones, for example, they're looking at, do I want iPhone, iOS operating system, or do I want Android? or perhaps there's some other features, the camera has this quality or whatnot. And only 13% of you said, really it's the design that we're looking at. But I'm going to be discussing the Apple v. Samsung case and what an article of manufacture is and what the damages can be for that, to show you just why design patents are extremely powerful in industries in which you might not have thought of in the past. So as I mentioned, the design patent covers an ornamental design on an article of manufacture. And really the Apple v. Samsung case was helping us figure out what an article of manufacture means in the context of a smartphone. But the real power here is in addition to your typical utility patent remedies, such as a reasonable royalty or potentially lost profits, the design patents have an additional method of recovery, which is disgorgement of the infringer's profits. And so next slide, please. The Apple v. Samsung case is really what is the leading case on this issue. And so this was a 6-year saga. Apple had sued Samsung, asserting a host of patents, including design patents and utility patents, but it really became a design patent case. And initially, Apple was awarded almost $400 million in damages, which was the extent of Samsung's entire profit on the Galaxy phones. And here is, again, there are multiple patents in the case, but one of them is shown below. And so you can see that Apple had a design patent on that shape. The solid lines are what their patented design are. And the Galaxy was the accused infringing device. And as I mentioned, the jury found infringement and awarded nearly $400 million in damages on that patent. So next slide. This eventually went to the Supreme Court in 2016. Justice Sotomayor delivered the opinion of the court, in which I believe there were 7 concurring, or not concurring, but 7 in agreement with the opinion, and only 1 dissent. There might have been 2, so forgive me on that. But what that case was really figuring out was, what is an article of manufacture? And so Justice Sotomayor, used the analogy of, there are certain objects like a dinner plate where you can tell that is the article that is the design. It's impossible really to separate the design from the actual article. But then there are other objects, such as a kitchen oven, that might have design elements, but it's a complicated enough machine to where there are other discrete objects within there. So you've got your burners or your oven or the drawer beneath. And so if you had a design patent, what is the actual article of manufacture there? And so initially the theory from the Federal Circuit had been, well, it's what's sold to consumers. And so that's how Apple was able to disgorge the entirety of the profit on the Samsung Galaxy. And the Supreme Court said, no, it's not defined by how it's sold to the consumer, and remanded it back to the Federal Circuit, which remanded it back to the Northern District of California to figure out what is an article of manufacture. And so you can see there is a 4-factor test, and I also am mindful that we've got 2 minutes left here, so I'm not going to read the slide to you, but hopefully you can pick it up as we send the slides out later this week. But the crux here is that after remand, there was another trial of infringement. The jury decided again in 2018 that, okay, the smartphone, the Galaxy, is the article of manufacture, so therefore Apple gets damages on the entirety of the profit for that Galaxy, and this time it was $533 million. The other thing that's interesting about that is there still were some design or utility patents in the case, but they were only worth about $5 million. So you can see the power here really of these design patents, where Apple had the patent portfolio strategy to patent a lot of its designs, and ultimately that became a very big win for the company. Next slide, please. So I wanted to see also what had happened with respect to district court cases after the initial Apple v. Samsung jury verdict in 2016. And I wanted to see the damages awards coming out of the design patent cases. And you can see, according to Lex Machina, 17 of the awards disgorged the infringer's profits. The high in that range was a little over $3 million, and that was on a knockoff of the UGG boots design. And a low was around $16,000. And this was on a furniture design. That case, that series of cases is actually kind of interesting because you might be thinking, why would a patent holder pursue a case through district court jury trial for $16,000? But there are actually a number of other damages theories in there, including copyright and some others, wherein it was a much larger case than that. But I highlight these numbers in part because only about half of the cases used the disgorgement model. And so what it really shows you is that there still are value to a reasonable royalty or perhaps your own lost profits when maybe perhaps this infringing entity isn't making a large profit on its design, but your entity would have, or the reasonable royalty comes up with a better result. You can see there the frequent venues, and then also just a couple of other considerations quickly before we leave. Design patents, they last for 14 or 15 years, depending on when you filed for it. It's currently 15 years from the grant. And if during that 15 years where you have exclusivity on that design, you start to market it as, this shape or this design being key to your product and making it indicia of source, you can then really easily convert it into a trade dress claim where you can have that trade dress in perpetuity. And so I think that's another reason to think about these design patents. And so with that, I'll just summarize. Next slide, please. Here's the key takeaways we wanted you to get out of this presentation today. First, robust intellectual property portfolio can really lead to additional revenue streams. Second, when you're considering monetizing your intellectual property, early assessment is really critical, and that includes the strength and validity considerations and also your enforcement strategy. And then third, that utility patents aren't the only valuable IP. There are many other things out there, many other legal mechanisms to protect your property and perhaps monetize it. And so with that, I'll turn it back to Angela, and thank you for your time today.
Thank you so much, Lauren. I apologize. I see we have a couple of questions we're not going to get through today, but all of the panelists' contact information is listed here on the slide or on the Lathrop GPM website. And feel free to reach out to any of us to follow up on your questions we didn't get to today. And on behalf of the entire panel, I'd like to thank everyone for joining. And I hope everyone has a great rest of their day.